I'll share a few thoughts on the parallel procedures and lis pendens rule in the recast regulation with you. So the system of preventing parallelism of procedures and judgments through regulations is multi-layered. However, the burden traditionally falls on lis pendens and related actions, rules which prevent contradictory judgments from arising. Parties are indeed keen to initiate simultaneous procedures before courts of different states, as they seek for legal protection in the fora which they perceive most beneficial for their own claim. Equally, the private international law rules may be applied in an abusive way, where one of the most prominent examples is the misuse of alternative grounds of jurisdiction that are available to applicants. The general private international law rule is that the second seized court states its proceedings. However, in piecemeal EU legislation, the formula of preventing parallel proceedings is used in variety of combinations. The common core is for sure in the Brussels Convention, or nowadays Brussels I recast regulation. Basic rules says that once the court is seized and declares itself competent, courts of other member states must dismiss any subsequent application. Any court seized must, on its own motion, question its jurisdiction. Once the jurisdiction of the court first seized is established, the court second seized shall decline jurisdiction in favor of that court. As established by the academics and Court of Justice of the European Union case law, the lis pendens rule is jus cogens. The mechanism to resolve situations of lis pendens is subjective and automatic. It is based on the chronological order in which the courts concerned are seized. Two methods of bringing proceedings before national courts or tribunals are envisaged, either by the lodging of the documents initiating the proceedings at the court or tribunal, or by service of that documents. In the European Union private international law regulations, this common core is the one that is also retaken by the Brussels II bis and IIter regulation. However, there are varieties and they relate to parallel proceedings among member state courts and third states courts, and there is a difference in the rule relating to the parallel proceedings where the court with exclusive jurisdiction has been second seized. If we look at the recast provision, we would clearly see that the provisions of Article 19 and 20 are equal with difference of paragraph 4 and 5. There are, however, certain other rules that may affect the lis pendens provision. So the first one is Article 20, where the provision on courts with exclusive jurisdiction by Article 10 is added. This provision is overtaken from the Brussels I recast, and the idea is that the provision on lis pendens should not stand in the way where parents confer exclusive jurisdiction on the courts of a member state. Regulation now provides for an exception to the general lis pendens rule in order to deal satisfactorily with this particular situation, where this rule actually aims to enhance effectiveness of exclusive choice of court agreements and avoid abusive litigation tactics. There are also other provisions that relate to or affect functioning of the lis pendens rule. One of them is Article 97, where the interaction with the 1996 Hague Convention is tackled, and prior proceedings before a court of state party to that convention would have precedence. And finally, the Article 86 dealing with cooperation between the court specifically affects the situation where information on pending proceedings is requested for the purposes of Article 20. Having in mind the previous research and possible pathways that were taken in national case law, which has been elaborated with some of our previous researches, we face the open question if the changes brought by the recast would enable smooth and non-abusive litigation in cross-border parental responsibility issues. And it is worth noting that the Court of Justice of the EU rulings in respect of Brussels Convention and Fort are valid, should be also applied in respect of the aspects of the provision which are identical in throughout the regulations. So the remaining problematic aspects would for sure be to establish that other member state court has been seized, or to establish and apply procedural law of other member states. As well, the evidences may be lacking, but one of the parties would raise the lis pendens objection. So some of these issues would maybe be dealt adequately with the revision of the provision on cooperation. However, the problem of parallel procedure in third state remains in a legal lacuna when the recast Brussels IIter is at stake. So we don't have any rule, we have some case law, but we also have very different national approaches. So we may for sure know that the issue is very controversial, as the member state either apply the same rule that applies to lis pendens in European Union, or if they still have national private international law rules, they would apply that provision to third country proceedings, which may be problematic taken in consideration the Ovuzu rulings. So we may conclude this area has been significantly upgraded over the years, as the basic or the common law provision is dating from the late 60s. Regrettably, the recast omitted some of important aspects of the Brussels I, and should have the Brussels IIter recast at least incorporate all of the provisions of the Brussels I. It would not be a revolution, as some of the issues would still be problematic, but it would be throughout evolution of the rule for sure. Thank you for your attention.